in here about how you acted while you were there and visiting with them.
Yes, ma'am. I was over the phone when me and the lady were arguing and stuff. I just wanted the information on when I was supposed to meet the dude that was there.
That's not how this reads.
They
were so frustrated with you that they said they will not do a pre-sentence report while you're on bond. So do you know what that means?
My bond has to be paid off.
No, that means I'm going to revoke your bond.
Okay.
And you're going to go to jail. Yeah. And then they're going to come to the jail and do the pre-sentence report. And you're going to be respectful to them. Or I don't have to go along with this plea agreement.
Yes, ma'am.
So listen, it's time to get a whole different attitude about all of this. I understand. I remember now when you were here, you don't like the whole situation. No, hang on. Don't overtalk me, because that's going to show me what you're doing to them. Okay. Now it's just the time to listen.
Yes, ma'am.
All right. And just do what you're told. There's not an excuse for what you did. That's not, you didn't just try to ask for some information. Okay. They wouldn't have sent this. They're very, very patient.
I just want to let you know I got a whole different view about it on the whole situation now too. I just got to meet my son for the first time on Friday. So
well, this is very unfortunate. Yeah. So you'll, but here's the thing. There's no reason for you to still not get this probation, but I don't have a choice now but to get this pre-sentence report done. So I'm going to, hang on. I'm going to revoke your bond in your case at this time. You're going to go with the bailiff. Probation's going to come to the jail. They're going to do this pre-sentence report. Probably not today.
Do I get a new bond today?
I'm not giving you a bond because you couldn't act right while you were on bond, which shows me that you see where I'm.
Yeah, can we just like revoke the deal and take it to trial? I can't afford to go to jail, please.
You're going to jail regardless. Why?
Yes,
because do you want me to read the memo?
The whole thing. Can we play the voice recordings of the phone call in here today too, if that's the case? Because if you're just going to believe what she says, then I believe I have the right to fight on behalf of what I have to say, and we need to be able to play those phone recordings.
You're going to go do that. You're going to go do that pre-sentence report.
Phone recordings today.
And you're going to go and hopefully be respectful and hopefully get this probation and not ruin your life over this. This is very.
As long as you think I'll be in it.
It's a very temporary situation. Mr. Rojas can come back and talk to you. I'm revoking your bond at this time. I find it's in the best interest until sentencing that there not be a bond. You can go back with the bailiff. All right, you're Malik Ellis. And Mr. Ellis was previously in court in cause number 1726733. Entered pleas of not true and a motion to revoke probation. It's my understanding that there has been, we're here for sentencing. I've gotten the pre-sentence report, but it's my understanding that he's going to enter pleas of true to some of the counts as change his pleas. Is that correct? And so will he waive the formal reading of that motion again?
Sure.
So let's go to the motion again. Mr. Ellis, so it looks like before you pled true to counts 3 and 6, and you're on probation for the second-degree felony offense of aggravated assault with a deadly weapon. That was a 7-year deferred probation that was extended for 2 years. Let's go back. Count 1 alleges that you committed the new offense of possession of marijuana, a Class A misdemeanor on November 18th of 2025. And is that true or not true?
True.
Count 2 alleges that you failed to report to the probation officer your change of address. Is that true or not true?
Not true.
Count 2 is not true. Still. Count 3. I'm making the modification here on the agreed punishment recommendation. Mr. Kimler, y'all wrote in 2, but he pled not true to 2 just now. So I'm going to.
There wasn't.
He was going to. On which counts he was going to plead true to. Y'all wrote in 2. I'm marking through 2 because he pled not true.
And I'll put on evidence of that for the court judge.
Okay. And then count 3, he already pled true to. Count 4,
we abandoned, Your Honor.
State abandons. Okay. And then count 5 alleges that you possessed an illegal drug, namely marijuana, and that you were in possession of it November 18th of 2025. Is that true or not true?
True.
And then you already pled true to count 6. So today you've changed your pleas and pled true to counts 1 and 5. And do you do that freely and voluntarily?
Mm-hmm.
And did you plead true to counts 1 and 5 because they're actually true?
Mm-hmm.
All right, then at this time, I'm going to find counts 1, 3, 5, and 6 true. And Ms. Malfino, you have evidence with regard to count 2?
Very briefly, Your Honor.
Yes, ma'am. And would you please raise your right hand, ma'am? Yes. Do you swear affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you. And if you'll just state your name for the record, please, ma'am.
My name is Shay Kane.
Thank you, Ms. Kane. Go ahead, Ms. Malfino.
Thank you, Judge. Ms. Kane, would you please identify what you do for a living for the record?
Yes, ma'am. I'm a community supervision officer for the Jefferson County Adult Probation Department.
And how long have you been with the department?
I have been with the department for a year, but I've been a probation officer for about 3 years.
And do you have occasion to know a Malik Jamal Ellis?
Yes, ma'am.
Do you see him in the courtroom today?
I do.
And is he one of your probationers that you supervise for this court?
Yes, ma'am.
And as a condition of that supervision, was he read all the rules and conditions, gone over those with him of what the court expected his behavior to comply with while on probation?
Yes, ma'am.
Was one of those that he at all times provide you with an accurate address of a residence and location of his job, et cetera, so that the community supervision department and thereby the court could find him at any time?
Yes, ma'am.
And if he changed this address, was he told or informed that he needed to indicate such to the probation?
Yes, ma'am.
Based on your review of your file and your contact with Mr. Ellis, the defendant, did he change his address and report such to you?
According to the offense report that I received on November 18th,
Hang on just a second. It's okay. We'll just wait till he calms down a minute. Maybe they'll come get him. All right, go ahead.
according to the offense report I received on November 18th, it had appeared that he gave the officers a different address on the report itself. And based on that, he had never told me about any different residential since I've been supervising him.
And based on your supervision, you also became aware that he was arrested and has now pled true to possession of marijuana back in November of 2025, correct?
Yes, ma'am.
Would this have been obviously in violation of his probation?
Yes, ma'am.
And in discussions between you and I last week, we decided not to bring a lab analyst to prove that up, even though we have the Trooper Lucio here in court today, based on the fact that 2 days later, he tested positive for said marijuana, correct?
Yes, ma'am.
And do you have some other thoughts that you would like to share with the court at the appropriate time with respect to what your position is as to continuing him or revoking him off this probation?
Yes, ma'am.
And can we hold on that for a second?
Yeah,
You do
yeah.
have additional for the
Yes,
court.
ma'am.
And Judge, I'd like to just wait following cross-examination, also ask at the appropriate time that with the thanks of the state, that Trooper be released this morning. He's here in court.
Any issue with the trooper being released? Thank you so much for being here, sir. You're free to go. We appreciate you.
Thank you.
All right, Mr. Kindler, do you have any questions of Ms. Kane?
Just want to be clear. So he filled out some paperwork and listed an address that was different to the one he reported to you.
It appeared that he told the officers at the time he was arrested, what I read on the office report, it was a different than what I had in my system. It was 845 Madison that I had, and it was a different address listed at the time he was arrested.
No further questions.
All right. No, ma'am, we're not. All right. Mr. Any other witnesses then?
I don't believe so. I'd like to cross-examine that witness if they're called, but
Yeah.
I think I know where that's going.
Do you intend to call any witnesses?
So I guess I can call Grace. She must talk. So
Well, I mean, is it
let's look at the office.
Go ahead.
with regard to what issue?
Where's your grandmother?
Oh, she was just there for the change of address part. She just there for support.
Okay, that's fine.
What explanation? I'd call Mr. Pelletin.
Raise your hand. Well, did they already swear you over here today? All right, go ahead.
What explanation do you have for the difference in the addresses?
It must have went out my ID. My ID saved my mama's address, but I stayed with my grandmother. When they came to pick me up from my warrant, they picked me up at 845 Madison.
But your driver's license, your ID says what?
751 Odom Road. That's my mother's house.
Okay.
That's what I was.
I stayed with my grandmother, which is the house that's on fire.
Okay. it's a law that you change your license when you move. So you can see the kind of issues that gets you in if you don't.
Yes, ma'am.
Right. So it's very important that you take care of that. All right. Anything else with regard to the actual counts?
Not from the state.
Okay. Then at this time, I'm going to find
Oh.
counts 1, 3, 5, and 6 true. Find sufficient evidence to find Mr. Ellis guilty. Mr. Kimmler, what is your position with regard to punishment?
Well, Your Honor, this is in 2017, so I guess he's been on probation, approaching 10 years, perhaps. I think it was extended one time. Obviously, he's had issues on probation, latest from having to do with marijuana. I would just observe that he was negative today in court on the drug test. I guess he has at least refrained from using marijuana since this last incident and the last time he was tested, and tested positive. The court, as it's presented, has the options, is presented to either keep him on probation or let him discharge or revoke him. I think there's a middle position where he could be unsuccessfully discharged from probation without being revoked. That may be an option that the court would explore instead of having just at the end of this period of time revoke him and send him to the penitentiary. There's an option to unsuccessfully discharge him from probation. And that would be what I would suggest if the court's inclined not to let him to sanction and not let him stay on probation, but to unsuccessfully discharge him from probation in lieu of revoking and send him to the penitentiary. Is there anything you want to tell the judge?
How long? Hold on. What's the time frame on getting the MRT class done? How long is that?
How long is it?
Process.
It's about 18-week course. It's in the probation office itself.
How many weeks do we have left? Is that something that could he get started on that next week? I don't know if that's where I'm going, but
Yes, ma'am.
hold on.
We just have to buy the book, and so we can get him into the program.
Ms. Malfina?
Judge, I would defer to anything this case has. We've spoken multiple times about the case. I know she's tried everything. I'd just like her to let the court know her thoughts.
Well, we can't extend again, can we? Or is there any time frame left?
So he's at his 9 years
So we could do one more.
at the very, yes, ma'am. That would be the max that
Gotcha.
we have left.
Okay.
And he has also been to ISF cognitive track as well. But as far as what I would possibly recommend would be to put him on the high medium risk caseload for the rest of the entirety if the court allows, 0 tolerant, and possibly place him on the drop program to continue the more in-depth testing if the court would allow.
Anything else? Ms. Malfina to add to that?
Judge, I don't have much. Of course, I would defer to Ms. Kane and the court. Obviously, the state is somewhat frustrated with Mr. Ellis not taking initial responsibility. That's what I think people should get favor for instead of having the trooper have to be here. And thankfully, we didn't have a $3,000 plane ticket for a lab analyst to then what he then wanted to come in and admit. I would have rather him taken responsibility. And I don't say that in the context of disavow him of his rights to contest it. It's just that if he's
No,
not,
it's a very frustrating
if he's
thing
not
for me
being
as well. And
forthright with the court, should he have the benefit of the continuance on probation? Is all. Not in the context of a not true. I understand that.
We take the blame for that, if I might, Your Honor, in a way, in dealing with these cases that I perhaps advise my clients.
I know that's something probably needs to be addressed. We've talked about recently on several of them because it's very frustrating to have people come and take time out of their day, out of their work. The state have to expend that just to, quote, set it for a hearing when if it's going to end up, if somebody did something, they need to take responsibility for it. It goes over so much more with me, I think with the state, with probation, and it should be something that someone is encouraged to take personal responsibility instead of saying, let's see if they can prove it.
If I might, I'll try to address that in the future.
I appreciate
I
it.
hate him to be harmed by something that I probably didn't.
I mean, you've been on probation for so long to be making these kinds of mistakes. You know, I could revoke you right now and send you to prison for 20 years. That's how serious this is. It's not a game. And I know you've been on it a long time, but I get the whole argument, smoking marijuana is not that big of a deal. Well, it is if you're on probation.
It wasn't like that.
Well, you got arrested.
No, I'm saying I made a mistake, but it wasn't, I don't just smoke weed, you know.
Well, but you have, because you've tested positive a few times. So I understand that maybe you don't all the time like some people, but you have. And you got arrested for it, for having it. And so here's what I'm going to do, Mr. Ellis. And I want you to take advantage of this because after all this time, you don't have the conviction on your record. You're about to get the opportunity of a lifetime. You've already gotten a huge opportunity. When I do things like this, what I'm about to do, and you don't take advantage of it, it is typically going to be a whole lot worse than if I were to just revoke you today. So I want to make sure you understand that you're being given an opportunity, finish this probation, and hopefully not have any more issues because it's going to be very serious if you don't. So I'm going to find that you, again, entered your pleas of true to counts 1, 3, 5, and 6 freely and voluntarily. Find those counts true, find sufficient evidence to find you guilty and revoke the probation. I'm not going to do that. I'm going to extend it that last year that we've got to extend it. So you've got 1 more year. You will be on the drop program. So you'll be tested more frequently. You're going to be on the high medium caseload, which means you'll have to report more frequently. That's the price you pay for getting in trouble, but it's a whole lot better than going to prison and having the felony conviction. If you do everything like you're supposed to between now and the end of that next year, you're off probation. If you don't, you're in prison. All right. Any questions?
Okay.
But for the court also order the MRT class that you had mentioned.
Yeah. So the MRT class was already ordered. I want that started within 30 days.
Yes, ma'am.
So you need to get a job if you don't already have one. You need to do whatever you do to buy that book. I want that class completed. No questions asked. I don't want you waiting until the last minute. It's 18-week class. I want it started within the next 30 days. That's in order. You understand? If you have any questions about any of your other conditions, don't wait for probation and then say, well, they didn't tell me something. Go say, am I doing everything I'm supposed to be doing? I don't want to go to prison. Okay.
One person.
What's that?
On the fees, but what am I supposed to be paying? Because I keep hearing visit fees.
So here's the thing. Talk to them. They can explain. There's different. You had fees, you have fines, you have different parts of that. You're supposed to be paying it all. And certain things that you pay go to certain parts of that. And they'll put it towards different things. Talk to your Miss Kane. Will explain to you what you've paid, what it's gone to, and what you still owe. Okay. But just ask her. All right. Okay. You're free to go. Thank you. So here's the thing. If you don't tell me your name, I'm going to put you in custody for not cooperating this morning. I'm not going to hold on. I understand what you're doing and what you're trying to do. It's not going to help you a single bit in court to try to play these games. Back with the bailiff, you're going to make it worse if you don't.
Yeah, respectfully, this is not a fair trial.
You don't get to say respectfully and then be disrespectful. I told you very specific instructions when you were here before that if you did not do what I asked you, then your bond would be raised and you would have to go back to jail. Good morning. Are you Nasir Brown?
I'm not here today on special appearance.
I'm sorry. Speak up so I can hear you.
Here today
You're appearing here today?
by special appearance.
Okay. What is your name?
I'm a third party intervener who's behalf of artificial legal entity, not Nasir Brown.
Okay. At one point in your, at some point in your life prior to being this third party, were you Nasir Brown?
No.
You're not him.
I'm a third party intervener.
So here's the thing. If you don't tell me your name, I'm going to put you in custody for not cooperating this morning. I'm not going to hold on. I understand what you're doing and what you're trying to do. It's not going to help you a single bit in court to try to play these games.
That's relative. That's it.
So are you Nasir Lewis Brown, or have you been him at some point in your life or not?
Yes.
Okay. So I'm going to call you by Mr. Brown because I'm not going to say all the words that you just said, because you have now identified yourself as Nasir Lewis Brown. And so, Mr. Brown, this is your initial appearance, and you have two cases. And cause number 26, I just asked you not to speak over me. So here's the thing, Mr. Brown. I'm going to be very
I
patient.
got the challenge subject matter jurisdiction going on record.
Your challenge of the subject matter jurisdiction is overruled. Let me go through what I need to go through, okay? So this is your initial appearance, your first day in court. I'm required to go through what you're charged with by indictment. In cause number 26, DCCR 03322, you're charged with a third-degree felony offense of assault family violence by impeding breath or circulation from February 16th of 2026. And then in cause number 26, DCCR 0323, you're charged with the state jail felony offense of injury to a child, and that's from February 16th of 2026. And so since you have made bond and got out of jail on your cases, have you had an opportunity to try to hire a lawyer?
This is what I'm saying.
Speak up so I
Up
can.
and down.
It's been up and down?
Yes.
Okay, so here's what I'm going to do, Mr. Brown, is I'm just like everyone else. I'm resetting your case about 30 days to give you some time to try to hire a lawyer. You need to try to get someone hired before the next court date. If you do, just bring the reset notice that you get today to that lawyer and they'll tell you what to do. If you're unable to hire someone before the next court date, then I'm ordering you to visit with at least 3 lawyers. They all charge different amounts, they have different payment plans. Bring me back the names of the lawyers that you've talked to so I know you're trying, and we'll discuss your options. If you don't do that, then when you come back, you run the risk of me raising your bond for not following that court order, and you would go back to jail. Do you understand? I'm sorry?
Overstand.
Say it
They
again.
overstand.
You overstand?
Yes.
Okay. What does that mean?
Overstand.
Do you understand what I'm saying, sir?
I'll block.
You'll
Block.
oblige.
I'll block. Yeah.
Okay. You just determined to use different words and be difficult, aren't you?
No.
Okay. So as a condition of your bond, did you have a condition that you were not to have any contact or communication with the complaining witnesses in each of these cases, right? Okay, and so I want to make sure you understand the importance of that. And that if you do have any contact or communication with either of them, it would be a violation of that bond condition. If I find out, your bond would be raised and you would go back to jail. Do you understand that as well?
Overstand.
You overstand.
Stay there.
I'm going to guess that overstand is even better than understand. So you definitely know what I'm talking about, right? So we don't have any miscommunication today. You know exactly what I'm talking about. So I'm going to have you step in front of the clerk. You're going to sign a reset notice so you know when to be back in court, and take care of those things before the next court date. All right, step in front of the clerk. Nasir Brown. Are you Nasir Brown?
I'm sorry. We were here before.
You've been here before, but you have to speak up where I can hear you.
Executing beneficiary of the trust in hand.
Of the trust of what?
Of the trust in hand, yeah.
Of the trust in hand? Whose
Yes.
hand? What trust?
The execution.
Did you bring a copy of it?
I wasn't able to get to the copy. I do
Take the glasses off. I need to see your eyes, please.
These are my prescription glasses.
That's okay. So I'm having a hard time understanding you. You need to speak up and speak clearly so that the record can be clear. You were already here and I gave you an opportunity to try to go hire a lawyer for your 2 cases. Did you get a lawyer hired?
Able to do it.
Who'd you talk to?
Made a few calls to the guy, wife. What's his name? Wife King?
Mm-hmm.
Wasn't able to get through.
Who else?
That's the lawyer that I chose.
So if you chose him, you should have gotten him. I mean, he has the same, there's somebody that answers his phone every week. I understand. I know how it works. I told you to hire someone or visit with at least 3 lawyers.
Made an attempt.
You made an attempt. Okay. Did you go see Mr. Kimler? Did you make an appointment?
Able to do that.
Why not?
I'm not in a position to go back and forth in front of a lawyer that's in this state that I'm not from. This is for the age.
So here's the thing, Mr. Brown, I told you very specific instructions when you were here before that if you did not do what I asked you, then your bond would be raised and you would have to go back to jail, right?
No.
Yes, that's exactly what I say, because you've heard me say it probably 8 times already this morning. So at this time, Mr. Brown, because you did not do what I asked you to do or what I ordered you to do, I'm going to raise your bond.
Challenge subject matter jurisdiction.
That's overruled. Listen, Mr. Brown, I'm raising your bond to $100,000 in each of your cases for not following the court order. Go back with the bailiff. Go back with the bailiff. Go back with the bailiff. You're going to make it worse if you don't.
Yeah, respectfully, this is not a fair trial.
You don't get to say respectfully and then be disrespectful. Go back with the bailiff.
She started,
Don't make me lay hands on you,
why would you lay hands on me?
because you're not doing what I'm telling you, now go.
Mr. Brown,
Go
you
back.
need to go back with the bailiff. Right now, I've raised your bonds. You have to go with the
I am
bailiff.
not a threat to any officer.
You through in, Judge?
Yes, I'm through.
I am not a threat to any officer.
Let's go.
Why are hands on me?
Yeah.
Why are
I
hands
told
being
you, I told you I was gonna put hands on you.
Why are hands being put on? Y'all see this on the camera?
Yeah, right there, put your hands on the wall. Put your hands on the wall, because you're not listening. Don't listen. I don't allow that.
Larzo?
Yes, ma'am.
And Mr. Larzo, in clause number 26, DCCR 0770, you're charged with the 3rd-degree felony offense of obstruction or retaliation from March 8th of 2026. Your indictment alleges that you were previously convicted of assault on a peace officer and assault on a public servant on October 12th of 2023, both of those cases on the same day, which means if you go to trial and are found guilty in these cases, or this case, and those prior offenses are true, that means you would be considered a 2nd-degree felony for punishment, which is between 2 years up to 20 years in prison. Do you understand all of that?
You can repeat that for me?
What part of it do you not understand?
The first part,
What you're charged with?
the part where you said.
So here's the thing. You're charged with obstruction or retaliation.
Correct.
The offense date is March 8th of 2026.
Correct.
And that's a 3rd-degree felony.
Correct.
The indictment also shows me that you were already convicted of 2 other felonies on the same day. What that means is if those are true, or at least one of them is true, it would enhance your punishment in this case to a 2nd-degree felony, which means if you go to trial, you're found guilty, the range of punishment is between 2 years and up to 20 years instead of 2 to 10. Do you understand? Sure.
Well, what it says is if you convicted, if you catch the case, 2 of the cases at the same time, then that would be consist of the enhancement. If you put both of those charges at the same time, I didn't catch those charges at the same time, even though I was convicted at the same time because they ran the CC.
Here's the thing. It only matters on one of them, right? Because the fact that they were run CC is what makes this enhanced by 1 instead of turning it into a habitual. So I'm only counting it like it's 1, right? So let's just assume you have 1 prior conviction. It doesn't matter if you have 1 or 2 or 14 from the same day, the same conviction day. It only will enhance this 1 level, which means from a 3rd degree to a 2nd degree, just like I said. Make sense? Okay. So
I'm sorry to interrupt,
Sure.
if I may.
Yes.
For the benefit of the defendant, I've tendered that pen pack to Mr. Rojas. The convictions are on the same day, but for the actual same type of offense. And in this instance, he threatened to murder a police officer, which is why the offer is what it is. And for his benefit, I also tend to introduce a punishment where available by the rules of evidence, the misdemeanor and juvenile contacts with the law that he has had as well.
all right. Thank you, Ms. Malfino. So you've had an opportunity to visit with Mr. Rojas about your case. And Mr. Rojas, do y'all have an announcement?
Judge, I was speaking with Mr. Larzo yesterday. I think his intention is to come here this morning and ask for a new lawyer. I explained to him the way to get a new lawyer is to reject the offer and set it for trial, because I think that was originally his intention. He, however, didn't want to sign any paperwork with me.
Because I haven't got an offer. You haven't gave me an offer. You said
5-year cap. I don't know what that is. That's not offer. If you offer me 5 years TDC or you offer me 5 years probation, you didn't say which one. So when I get an offer, I'll let you know. I don't know what the offer is.
Sounds like the offer was a 5-year cap. Is that correct,
That's the
Mr.
offer.
Rojas? And I'm sure Mr. Rojas explained to you what a cap is.
Yeah, he just said I can't get more than 5 years.
Right.
Okay, so what is the offer? How many years? 5 years TDC?
So it's up to me. So if you sign for a cap, and I'm sure Mr. Rojas explained this to you, it's a way for you to try to come to me and say, give me less than 5. I could give you 5, 4, 3, 2, or I could consider probation. It would all depend on the information that I received at a sentencing hearing. But if I follow the agreement, I couldn't give you more than 5. So it's something where it's not for sure. You have an opportunity to ask for something within that range. Does
I'm
that
trying to handle this today.
what?
I would like to take care of this today.
Well, talk to your attorney and listen to what he has to say. And if y'all want to take care of it today, then there's some paperwork that you have to go over with and sign, and then we'll go forward. All right. You can go back with the bailiff. Birds are allowed. Yeah. All right, Mr. Larzo, what's going on?
But ma'am, I'm going ahead. I want to request a new lawyer. He's not representative.
Here's the thing, you don't get to do that. So here's where we are. Mr. Rojas is a great lawyer. He's not just because
Can I speak?
nope, not while I'm talking. I already gave you an opportunity earlier, and I'm gonna give you an opportunity in a minute, but I want you to listen carefully to what I have to say first, okay? Mr. Rojas is telling you what the district attorney's office is offering. You don't have to like it. It doesn't mean he's a bad attorney. And another attorney is not going to come get a different offer.
Okay.
So, Ms. Malfino, is there any reason that you would know of that offer that you have made would change?
No, it will only go up.
So you're where you are. So either you accept that offer or we set your case for trial. Once your case is set for, hang on,
I want a new lawyer. I don't.
hold on. I understand, but listen,
Let me speak, man. Please, can I speak?
I'm going to let you speak, but I'm going to give you what your options are. Okay.
All I want is a effect. What I'm saying, you trying to say trial, this and that. I haven't even seen my discovery evidence. You saying he's a good lawyer, but he haven't even shown me no evidence. So on my case, how can you speak and say he already told me the other day that he working for the DA? He already said,
sure
I said, he have not one asked me what happened. He haven't even got my side of the story. Have you got my side of the story? Have I told you what happened in this case? Can you tell this person what I told you?
Mr. Larzo, you're not in charge and you're
I'm
not
not saying
asking
I'm not in
questions.
charge, but what I'm saying is, how can he say he can represent me and he's ain't done nothing but come to me and say the DA said this, the police report said this. He has not.
That's the evidence. That's what he's telling you. The evidence is what's in.
That's what the police report said, but he hasn't asked me my side. And
Here's the thing, your side is important. If you didn't do it, what his job is to tell you this is the evidence they have against you. You can take this deal, or if you say you didn't do it, you can go to trial. So if you're saying you didn't do it, then let's get a jury to determine if you did it or not.
I haven't seen no police report. I haven't seen no body cam footage. I haven't seen no evidence to where I can tell you if I'm ready to go to trial.
Is there media in this
Judge,
case?
if, as Mr. Rojas does in every case, he has requested and reviewed the discovery well in advance.
Let's do this. Do you have some media?
Judge, I have requested the media. What I told Mr. Larzo yesterday when he told me he wanted to watch the video, I told him we could reset the date to look at the video. He just said he didn't want to do that. He just wanted to come in and ask for a new lawyer.
I want a new lawyer because you now represent me effectively. You come to me and tell me the DA said this.
Mr. Larzo, he's just said that yesterday he would bring the video. Don't talk over me. He would bring the video for you to watch. I'm going to reset your case for 2 weeks. He's going to bring the information. You can watch it and you can make your decision. The offer is what the offer is. The DA's already said that. I don't care if you take it or if you don't take it. Take it, fine. Don't take it. We'll get your case set for trial. You need to be respectful. Mr. Rojas is going to get out there, show you everything. You don't get to keep copies of things by law. He doesn't get to hand you a police report and you keep it. That's part of the law. So he can go over that with you, read what it says to you, show you the video, and then you can make your decision. Go back with the bailiff.
May I ask a question?
Nope, I'm done today. Go back with the
I'm not
bailiff.
understanding how you can give somebody 4 years for an aggravated charge
Let's go.
and try to offer me 5 years for non-aggravated.
Actually, he's not happy with that.
DeMarcus Elam, wait, hold on, Mr. Burbank, what are you doing on, Mouton?
I missed the time,
I know, what's the announcement?
I'm still on discovery. I just got appointed and I've talked to her. I think also based on that, I may need to have her evaluated somewhere between here and there. My request, based on the circumstances.
What?
Evaluate.
Somewhere between here and there?
Yeah, well, my motion is here between here and there. It's the evaluation. It's coming.
Okay.
Like today or tomorrow.
Okay, we'll reset this Mouton.
And I've talked to her. She knows what's going on and
All right, yeah, if you'll make sure you get that in,
She's
we
happy.
will get her, evaluated as quickly as possible.
maybe I can convince Mr. Smith to.
DeMarcus Elam,
Just
yeah, DeMarcus Elam. Mr. Smith, you've got DeMarcus Elam, writ hearing. Good morning. Are you DeMarcus Elam?
Yes, ma'am.
And this is cause number 26, DCCR 1221. Mr. Elam is charged with the first degree felony offense of murder. And Mr. Reynolds was appointed as attorney. Ms. Holmes is stepping in to help out on that as well. And they have filed a writ requesting for a reduction in Mr. Elam's bond, which is currently set. Oh. Yes. Oh.
Yes, I believe Mr.
Did I
Elam.
know that ahead of time?
I'm sorry if I didn't make that clear.
No, I guess not, because I'm not gonna, so here's the thing, when you have an attorney, you don't get to have what we call dual representation. So if you, and I don't mind,
I think if I could clarify, it was filed pre-indictment. I'm not sure when Mr. Reynolds was placed on it, but Mr. Elam had filed the writ prior to being indicted, and then after the writ was filed, his case
was indicted.
was indicted.
So it's been indicted at this point.
Yes, ma'am.
Okay. So here's what I'm going to do. What's the bond currently set at?
2 million.
Okay. So what I'd like to do, I'm not going to, because the case has been indicted. At this point, a writ is probably not the appropriate tool. I would think it would just be a motion for a bond reduction. Ms. Holmes can talk with Mr. Reynolds. They can get that filed. They're going to file things on your behalf. Okay. And so I understand that you were waiting on an indictment but that's been taken care of now, but you don't get to file something if you have an attorney. I'm going to take what they filed. So let's get a bond reduction. Ms. Holmes will get that filed for you. I'll reset the case 1 week, but I think we need to have the appropriate tool moving forward legally. Let's do 2 weeks, and we'll have a bond hearing. If the state has any evidence, that'll give them some time to bring anybody, if you wish, on a bond reduction hearing. Okay, so we'll see you back in 2 weeks.
Okay.
Good morning. Are you Joey Mink?
Yes, ma'am.
And Mr. Rojas, will your client waive the formal reading of the motion in each case?
He will, Your Honor.
I'm gonna need.
And Judge, I'm going to give you a heads up on this. The motions were, you're going to shake your head if they don't match up, or if they've been administratively difficult, for lack of a better.
Let me get them printed out real quick, and we can all be.
At one point in time, the probation department only wanted one filed, and then the clerk asked why there wasn't 2 filed, brought that to my attention. So I filed the second one. So if there's errors, I apologize in advance.
So we'll just start with the first one. There's Mr. Mink in cause number, and he'll waive the formal reading in both.
He will.
Okay. So Mr. Mink, in cause number 23 DCCR 1851, I have a motion to revoke your unadjudicated probation. Shows that you were placed on probation July 1st of 2024 for the third-degree felony offense of evading arrest or detention with the use of a vehicle. And that was a 4-year deferred probation. Is that correct? And in cause number 24 DCCR 0294, I also have a motion to revoke your unadjudicated probation. Shows that you were placed on probation July 1st of 2024 for aggravated assault with a deadly weapon, a second-degree felony, and that was a 6-year deferred probation. Is that correct? Both of these cases allege that you violated your probation. Count 1 in each case alleges that you violated the special amendment requiring you to successfully re-enter the SAFE program. And is that true or not true? True or not true? And then in cause number 24 DCCR 0294, that motion also alleges in count 2 that you failed to provide verification of performing the community services required. Is that true or not true? True. And count 3 in that case alleges that you're behind in your court assessed fees. Is that true or not true? Did you enter your pleas of true to all of those counts freely and voluntarily? And did you plead true to them because they're actually true? In both of those cases, I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you sign these, did you go over them with Mr. Rojas?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand if I follow the agreements that you've made with the district attorney that you'll be waiving or giving up any right to appeal? State tenders number 1 in each case?
No objection, Your Honor.
It's admitted in each case. And is the punishment the same?
Yeah.
Okay. All right. I'm going to find in each of your cases that you entered your pleas of pleas are true to counts 1 in the one case and then 1, 2, and 3 in the other, freely and voluntarily. Find all of those counts true. In cause number 23, DCCR 1851, find sufficient evidence to find you guilty, and at this time find you guilty of evading arrest or detention with the use of a motor vehicle. Sentence you in accordance with your agreement to a term of 4 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. And then in cause number 24, DCCR 0294, find counts 1, 2, and 3 true. Find sufficient evidence in that case to find you guilty, and at this time find you guilty of aggravated assault with a deadly weapon. Sentence you in accordance with your agreement to a term of 4 years in the institutional division of the Texas Department of Corrections. There will be an affirmative finding of a deadly weapon in that case. The 2 cases or the 2 sentences will run concurrently, which means together at the same time. I'm going to hand you in each case the trial court certifications that shows that these were agreements that I followed, and so you've waived your right to appeal. I also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgments entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. If you have any questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Rojas. All right. Good luck to you, sir. You can go back with the bailiff.
Okay.